if the quality isn't good, it's just the risk we take, right? So the idea is to record it, and then it would be posted to YouTube if it's of sufficient quality. Each of you have 20 minutes, approximately 20 minutes. In the last oral argument, I botched the timing a tiny bit because I forgot to start it, but you could feel free to glance down at your own computer or clock so you just kind of have an idea, but I will do my best to monitor. I'll also try to give you a 5-minute warning, although I can't guarantee you that. Also keep in mind, we've read the briefs, we've discussed this matter in conference this morning. So I think with that, Mr. Rosser, I think the floor is yours.
Thank you, Your Honor. Yeah, good morning, and may it please the court. I'm Gary Rosser, and I represent the appellants, the Siglindi Stick Irrevocable Trust, and Lindy Ryan-Smith, trustee. You've indicated that you've read the brief, so I'm sure you're aware that this is a matter arising out of a landlord-tenant dispute. And the main question in this case is whether or not possession was delivered from my client to the plaintiff, Ms. Smith. Obviously, we believe that it was, but I think before we go into that, I want to talk about the verdict itself, and because we can extrapolate from the verdict, even though it wasn't a special verdict, what the jury based its verdict on. The verdict was $26,566. During the trial, Ms. Smith testified that she paid prepaid rent and a security deposit of roughly $7,500 and then had an additional $2,500 in damages for a total of $10,000. So unless there was some sort of penalty or treble damages, the most she could have recovered was $10,000. Obviously, she recovered more than that. There's only one of the causes of action in which she could get to the $26,000, and that is the claim for failure to provide possession under 33-1362. Under that statute, if my client had breached that statute, the plaintiff would be entitled to her $10,000 plus up to 2 times that amount. And in extrapolating, and I think Mr. Keim in his brief agrees, the $7,500 was tripled to bring us to a total of $22,566, and then there was a $4,000 additional amount, which I would assume would be her incidentals, that additional damages that the jury awarded to her. Again, the only way we can get to that number is if my client had failed to provide possession of the property. First, I want to deal with the denial of the motion for summary judgment filed by my predecessor and heard by Judge Warner. It's styled as an argument that the lawsuit is not permitted because of res judicata, but in essence, it is really a claim preclusion or collateral estoppel argument.
Counsel, you mean issue preclusion, correct?
Yes, issue preclusion, I'm sorry. And the issue being possession of the property.
Okay, so counsel, walk us through this a little bit, because it's my understanding that we as an appellate court generally do not consider on appeal denials of motion for summary judgment unless one of 2 things happen. Either it needs to be renewed at trial, or it has to be a pure question of law. So how do you explain to me how you get past that hurdle of showing that you fall into one of those 2 buckets? Putting aside the claim preclusion for a minute.
So I would concede that we did not raise it again at trial after the motion for summary judgment was denied. However, it is an issue of law as opposed to the fact, because the court should decide whether or not the judgment that was entered was a decision on the issue of claim preclusion. And it had to have been, because the only issue that the justice of the peace could decide was the right to possession.
Counsel, but was that right to possession in the past or in the future? Like, you could normally haven't handled too many of these, but a couple of forcible detainers in my career, but you go in there to establish who has the right to possession from that day forward. Correct? I don't know
that is correct.
What evidence is there in this record that the court made a determination and looked backwards and made a determination that on that day of that walkthrough or whatever, that one party or the other had the right to possession as of those dates?
So if we're looking backwards, then the court actually did consider some evidence regarding possession, specifically the lockbox log, which showed that the plaintiff's agent took possession of the property by taking the key out of the lockbox on August 26th, which was the date that the parties were supposed to have a walkthrough and fill out a walkthrough sheet regarding any damages to the property that either needed to be documented or repaired. And so it's essential that the court decided that Ms. Smith had possession and then awarded possession to the trust. The judge could not have awarded possession to my client if she already had it. And the judgment indicates that it's awarding possession to my client, and that was Exhibit 33.
Okay, didn't counsel for Ms. Smith, didn't they concede, or I don't know what the right word is, stipulate or concede that there was entitlement to possession for the trust?
They surrendered at that point. She did make a statement that she never took actual possession, and we agree with that statement. There's no evidence that she ever took actual possession.
Is there case law that supports when you surrender or you stipulate or concede the point? Does that mean it's actually litigated under the issue preclusion principles or factors?
I did not find a case specifically with those set of facts that would support that argument. But as looking at what the court had to deal with, it had to have made a decision on who had possession and then who was entitled to possession.
Okay, and then give me your best argument on why you think you preserved the issue preclusion when you didn't call it issue preclusion in the Superior Court. Yeah.
I've already conceded that we didn't re-raise it at the trial, but it is merely a issue of law.
But no, counsel, I'm saying, did you ever raise collateral estoppel or issue preclusion in the Superior Court proceedings, whether in the motion for summary judgment proceedings or later? I thought you only raised res judicata or claim preclusion.
Well, it was labeled. My position is that it was labeled res judicata, but it was really issue preclusion. And Mr. Keim actually helps us out on that a little bit in his objection to the motion for summary judgment, because he discusses collateral estoppel as it was discussed in Corbett versus Manor Care, and that's on page 8 of his objection to the motion for summary judgment filed, the first one that was filed in 2017.
Okay, thank you.
So as we've already discussed, we believe it's already been litigated. Obviously, a final judgment was entered, as it was. The judgment was entered as an exhibit at the trial. Ms. Smith had notice of the hearing. She sent counsel to represent her at the hearing, although she declined to appear at the hearing. Her attorney did ask if the hearing could be set for trial or continued so that his client could get there, and the Justice of the Peace denied that request. And then again, as we discussed, that fact is essential. It's actually essential to most of the causes of action, if not all, that survived to the stage of the jury deliberation. And so the judge found that there had to have found that there was possession with Ms. Smith. Obviously, after looking at the log and seeing that her agent had taken the key and that possession was now was appropriate in my client, and then he awarded possession to my client in the judgment. Next, I'd like to move on to the judgment as the motion for judgment as a matter of law that I made following the plaintiff's case. There were only six causes of action of all the plethora of claims made by the plaintiff that survived to the jury, and Judge Gates did not. She didn't specifically enter rulings regarding some of the claims. She simply excluded them from the jury instructions, and that exchange is clear in the argument on the motion for judgment as a matter of law. I would raise a claim and she would say it's not in the final jury instructions, which I took to mean that she had granted my motion for judgment as a matter of law as to that issue. So the six issues that survived were the breach of obligation of good faith and fair dealing. In the case, that only dealt though with the failure to provide possession. So again, it revolves around this issue of possession. And if my client had delivered possession to the plaintiff, then her claim would fail as a matter of law, that she had breached the duty of good faith and fair dealing under the Residential Landlord-Tenant Act because she had provided possession. The next cause of action is 33-1362, which is the failure to provide possession, which we already talked about. That has the treble damages, and that had to have been, the jury may have found my client liable under other theories, but they had to have found it under that theory to get the damages to the number that they got it to. If they would have simply have found that she breached the 33-1311, the duty and obligation of good faith and fair dealing, she would have only been entitled to recover the $10,000 and not anything more.
Counsel, let me jump back in.
Sure.
It sounds like you're advocating for challenging the sufficiency of the evidence here as to certain claims. But the way I understand the briefing and how that occurred is that because the Rule 50 motion wasn't renewed, that we don't have jurisdiction to consider that, or that's the argument I believe that Mr. Keim has made. Is that not the case?
That is not the case, because we're not arguing that the evidence presented at trial wasn't sufficient. The argument is that twofold. One, that it was already decided and precluded, that issue was precluded, and two, that the facts presented in support of those claims had so little probative value that a reasonable person could not find in favor of the plaintiff, which sounds like it's sufficiency of an argument about sufficiency of the evidence, but if you read the cases, they all deal with them separately. So they're two separate concepts, whether or not there was sufficient evidence versus whether or not the evidence that was presented had no probative value. The third issue then would be under 33-1374, which is that the landlord took possession of the premises. This one's important because they are claiming both that possession was never delivered, and yet my client took possession back from the plaintiff. Unless the plaintiff had possession, my client could not have violated 33-1374 because she would have already had possession. She can't retake possession from herself. She can only retake it from the tenant, and that's exactly what they allege. The next cause of action is 33-1321, which is relates to the security deposit. And again, the time starts to run from the date that possession is given back to my client, which is the date of the hearing and the eviction action. And if you look at the dates, the date that she sent the explanation of the security deposit to the plaintiff, it was simply, it was about a week after the eviction hearing. So it was certainly in plenty of time, as 1321 requires it within 14 calendar days, I'm sorry, judicial days of the retaking of possession.
Mr. Russer, just so you know, you have about 4.5 minutes left.
Yeah, I've actually got a timer running as well. Thank you.
Okay, great.
I'm actually going to jump ahead so that I have enough time to address it, and that's the jury instruction that was rejected by the trial judge. There is in the Residential Landlord-Tenant Act a definition of delivery of possession, and it references delivery from the landlord or from the tenant to the landlord. There is no specific definition in reverse, but they clearly use it as a technical term rather than as a term of just common sense, as the trial judge ruled. There would have been no reason to define delivery of possession had the jury been allowed to determine whether or not the tenant returned possession back to the landlord. The proper jury instruction was simply a mirror of the definition for returning the possession back to the landlord.
Question for you on this, Mr. Rosser.
Yes.
Even though the trial court rejected the proposed jury instruction, did the court still give your client a chance to argue that at trial?
When we were settling final jury instructions, well, first she declined to give it in the preliminary instructions as requested, and then we addressed it again when we were settling final jury instructions, and she said that we could argue it and argue that it meant whatever common sense tells you it means, even though as it's used in the statute, it really has a technical meaning. The example being, if the actual tenant on the lease moves out and leaves behind the unemployed brother-in-law, they haven't delivered possession. Common sense may say that they have, but one of the requirements under the definition is that the premises be empty. With that, I'm going to reserve the remainder of my time for rebuttal.
Thank you, counsel. Mr. Keim?
I just lost him.
I think he just stopped his video and he's muted.
I think he's trying to stand up and adjust the camera.
Okay, there you go. We got him back.
Hopefully I'm there.
Okay, good.
Thank you, Your Honor.
We can see you. Yep, great. Go ahead.
May it please the court, I'm Barry Keim, representing plaintiff appellee Sabrina Smith, the tenant in this case. And the landlord presents 4 issues on appeal, and I'd like to talk about them in two groupings. So the first one is the collateral estoppel issue, but this also relates to the jury instruction issue. So issues 1 and 4. Landlord would have it that, and Mr. Rosser just said it, maybe in the starkest terms I've heard, that possession was the main question. The delivery of the possession to the tenant at the time of the meeting, Your Honor alluded to, that's the main question. Well, we differ with that. In fact, it would not make a difference, I submit, if that possession were given and then taken away. If that possession were given and then interfered with, if that possession were given and the security deposit were mishandled, it would not make a difference in terms of our claims and the claims that were before the jury, and based upon which the jury entered a unanimous general verdict. Mr. Rosser, I hope unintentionally chose not to speak about 33-1367, which is the unlawful prohibiting of access by a landlord to a tenant. And that too allows for this additional penalty that gets you to the total verdict number that we have. So we have 3 times the amount wrongfully withheld, and then we have another $4,000, which is equivalent to 2 months' rent. And those 2 months' rent can be awarded either for the failure to deliver possession or the unlawful prohibiting of access, which we argued here. And I don't want to concede that there was possession delivered. In fact, even if it had been momentarily delivered by the tenant agent taking a lockbox key, when it was demanded by the tenant who never had occupancy of this property, when possession was demanded by the tenant, the landlord refused. That too would be a failure to deliver possession, we submit. And so the reason I want to mention issues 1 and 4 together is that question of the momentary possession because of a real estate agent using a lockbox key is not dispositive of this case. And with regard to the jury instruction, the landlord is not prejudiced by the absence of some bespoke jury instruction regarding what possession means going from a landlord to a tenant versus the statutory definition of tenant to landlord. And by the way, the landlord presents no basis that I know of for the notion that what's appropriate here is a mirror instruction, that because the legislature chose to provide the basis, the definition of a tenant giving possession to a landlord, that somehow there's an entitlement to a mirror of that instruction for the landlord giving possession to the tenant. That escapes me.
Counsel, what would have been adequate to constitute possession, transfer of possession?
Well, Your Honor, certainly the taking of actual possession by the tenant would have been.
So if he gets the key to the place, that works.
Well, the key being offered to the tenant's agent, we would submit is at most constructive possession, but the agent had no authority for that. In fact, we have testimony in the record, I think we quoted from this, that the landlord's agent said under the circumstances that existed at the time, she would not have taken possession for that tenant. There was no, that deal, the landlord by that point had repudiated the lease. And I don't want to spend too much time talking about carpet, but there was this carpet issue and they couldn't come to terms, but worse, just before that meeting, the landlord took the position that the existing carpet was not going to be removed, period. Well, that's not the landlord's right under the lease. So the landlord repudiated what was to the tenant a main provision of the lease. And so when that meeting occurred, it actually was a critical meeting to determine if there was going to be a lease. if it was going to continue.
But wait, you insist that he left the place with the key. And he was recognized as the agent of the renter.
No, sir, and I apologize, but I must correct that. No, there was, viewing the evidence in the light most favorable to sustaining the verdict, there was ample evidence that the agent did not leave with the key. The evidence was that the landlord left and locked the place up. That effectively locked our client out, because there was the agent stated adamantly she didn't have a key. That was the whole issue of the tenant demanding possession after that meeting. The tenant had no means of possession, and there was no acceptance of possession by the agent. I know that the landlord would prefer it that way, but it didn't happen. And when it was made clear to the landlord that it didn't happen, the landlord affirmatively refused access. So it wasn't that the landlord said, oh no, we don't need to trouble ourselves with you because you already have access. It was, you are denied access. That, we contend, was the end of this lease and entitled our client to her money back. She demanded, I want my money back or possession. They refused access or possession, and they refused to give her money back. So they this issue of whether there was possession initially for a moment is a red herring. It is not important to the conclusion of this case or the decision that was made by the jury in this case. The jury concluded that my client was denied occupancy of the property, that my client's funds were wrongfully withheld. And by the way, the 14 days is its own somewhat of a red herring. It's not just that that statement had to be given to the tenant in 14 days. It's also that the money had to be returned. And that did not happen. That didn't happen in 14 days or ever. And so the jury could conclude under 33-13-21 that there was a violation by the landlord entitling the tenant to her money back and treble damages, that the landlord had unlawfully prohibited access under 33-13-67, adding additional penalty damages, which give you the amount of our verdict. And with regard to the sufficiency of the evidence, the landlord concedes that any argument of the sufficiency of the evidence to support the jury's verdict has been waived, that it was not preserved. That concession, though, also applies to the argument that the trial court erred in failing to grant the judgment as a matter of law, because that also requires a consideration of the sufficiency of the evidence. And I submit that it is for good reason that ARS 12-2102C says that the court does not have jurisdiction to hear these appeals unless the trial courts had a chance to rule on these issues through a post-trial motion. Because the trial court should get a chance to say whether there was sufficient evidence for the jury's verdict. The trial court should get a chance to say whether there was appropriate evidence supporting the denial of the motion for judgment as a matter of law.
Counsel, Mr. Keim, what about Mr. Rosser's argument that he says the case law differentiates between challenge to the sufficiency of the evidence as opposed to a challenge where there's a complete lack of probative value of the evidence? Do you recognize that distinction, or is that valid in your mind?
I do not recognize that distinction, but if you apply, even if it were applied here, the evidence was probative with regard to each of the issues we've raised. And I'm not sure I follow the argument, frankly, Your Honor. So whereas here there was ample evidence that there was a breach of contract, that there was a breach of the obligation to provide access to the property, that there was a breach of good faith, and where there was evidence to support the penalties that were imposed with regard to the wrongful withholding of the tenant's funds, and with regard to the interference with or prohibiting of access by the tenant. We submit that there was ample support for the jury's verdict, that the trial court acted correctly in denying the judgment as a matter of law on those issues, and that the verdict and judgment of the trial court must stand.
Thank you.
No further questions.
Okay. If no other questions from the court, thank you, counsel. Mr. Rosser, got a couple minutes.
I think you're muted, Mr. Rosser.
Sometimes I'm sure my wife wishes she had that button. So I'm gonna circle back to the main issue again, and talk a little bit about the evidence. The evidence is uncontested that Ms. Seacrest, the plaintiff's agent, took the key. There's no evidence as to her telling my client or any of its agents that she was not taking possession or that she returned the key. In fact, she says in an email afterwards that she doesn't know where the key is. Perhaps she left it there, ? So, but once she took possession of it as the agent for the plaintiff, and the lease term had already started, the plaintiff had possession. The only reason the plaintiff didn't get possession on the day that Ms. Seacrest took the key out of the lockbox is because even though it was provided for in the contract, Ms. Smith, the plaintiff, failed to show for the walkthrough. She sent her quote-unquote ambassador, who I understand was her employer and boyfriend, to lay down the law as to what was going to happen. And if you read the transcript, you'll see that. And there was never any discussion about the walkthrough. It wasn't a walkthrough, and she simply just frustrated obtaining possession on her own. Additionally, it was tendered to her even before the term of the lease started in the August 19th email, where one of my client's agents said, take the key out of the lockbox and give it to your client. The testimony also was by Ms. Seacrest that is very typical, that when you either are selling a property or leasing a property, the key, the agent gets the key and gives it to the buyer or the lessee. With regard to the issue of whether or not we could have gotten up to the damage number for violation of the security deposit statute, Mr. Keim simply misstated the law. The law is it's the greater of 2 months' rent or 2 times actual damages. So if they found her actual damages were $10,000, which is all she presented, she would have got a $20,000 verdict, not a $26,000 verdict, because that was the greater of the two, the rent only being $2,000 a month, so that was only $4,000. He talks about constructive possession.
Counsel, why don't you take another 30 seconds or so and wrap up?
Certainly, Your Honor. He talks about constructive possession. He didn't cite any authority for the concept of constructive possession, and then that possession is somehow eliminated after the agent loses the key. What they were really asking for was, what my client was really doing was not excluding possession. She was declining to provide another key because the tenant's agent lost the key. And I'll stop there, Your Honor.
Okay, thank you both, counsel, for your patience and for agree, or not necessarily agreeing, but working with us to accomplish these oral arguments. It's been helpful. We will, the court will take this matter under advisement and issue a decision in due course. So the